Hey folks, it's Denise, Howell, and next up is This Week in Law. Harry Surden is with us, Evan Brown, Karl Susman. This week, the U.S. Supreme Court heard a huge GPS tracking case. We're going to unpack that one. Net neutrality is still alive in its watered-down form. Courts are ordering Facebook logins turned over, and contracts are getting more automatic. Next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 137, recorded 11/11/11. iLaw, Justice Inside. This episode of This Week in Law is brought to you by Ford, featuring voice-activated Sync App Link. Now you can control select smartphone apps with your voice, so you keep your hands on the wheel and your eyes on the road. Check it out in the 2012 Ford Fiesta and at ford.com/technology. And by Netflix. Watch thousands of TV episodes and movies on your PC, Mac, iPad, iPhone, or TV instantly. All streamed directly to you, saving you time, money, and hassle. For your free 30-day trial, go to netflix.com/twit. Hi, it's Denise Howell here, and you've tuned in for This Week in Law, episode 137. We're here on 11/11/11, Veterans Day. At 11:12 a.m., we just missed our 11/11/11 start time. Oh, well. But we're here with a great panel of folks, I'm sure you will agree, to talk about some very interesting stuff that has happened this week in the world of technology and internet law. And joining us today, we have a professor from University of Colorado, the Boulder campus, Harry Surden. Hello, Harry.
Hi, thanks for having me. It's a real pleasure being here.
It's wonderful to have you. I know that Evan caught you at a conference sometime a while back and has been begging me to get you on the show, so I'm glad that we were able to do that. Also joining us is Evan Brown, back after a couple of weeks off from the show. Hi, Evan.
Hey, how's it going, Denise? And it definitely is great to be back. I missed a conversation, and I'm really looking forward to this one. This one's going to be a fun one today. So thanks for having me, and it's going to be a good one.
You're sounding awesome. I understand you were victim to laryngitis last week, which is really difficult when you're doing a show like this. So
it is, and it's just one of those things you take for granted, being able to speak, and especially in our line of work that we're in, it's one of those things where you don't realize how difficult it is unless that faculty is taken away, even temporarily. So great to be back among the living.
Right? Did you have to wander into court with big signs over your head to enunciate your arguments, or did you just stay out of the courtroom for a while?
Stayed out of the courtroom and, tried to delegate client calls and things like that. So it's much easier to not have to engage in any of that. So it's much better this way, that's for sure.
Well, we're glad to have you back. And
Thanks.
Also rejoining the show, I think the last episode you were on was episode 81. Karl, it's great to have you back. Karl Susman.
Wow, that long ago. Thanks. Wow, I'm listening to this and I'm thinking the big question we all have is if an attorney loses their voice, insert joke here, but are they still able to bill? That's the question. There has to be something else that can be done during that downtime.
Oh, yes. Plenty of attorneys never even have to talk. They just jump on their computer, do their research, write memos, wade
I don't know. I think we ought to spend at least a 0.1 or a 0.2 discussing this issue before we really give an answer on that. So
that's right. And for those of you who have been fortunate enough not to have ever been billed by a lawyer, 0.1 and 0.2 is usually 6-minute increments. So before we let one of those go by too much longer, let's jump into the exciting things that have been happening in the world of technology law this week. And I would say probably the most exciting is the United States Supreme Court heard the GPS tracking case that we've been talking about for a while on the show, U.S. versus Jones. The issue in that case was that law enforcement officers placed a tracking device on someone they suspected to be, I don't know if you would characterize the guy as a drug dealer or a drug intermediary, but it was involved in a drug investigation. Their warrant, unfortunately, for the tracking device had expired when they put it on the car. And they gathered evidence, nevertheless, using that tracking device, and it was challenged and has wound up before the Supreme Court, whether it was okay for them to warrantlessly track the fellow. And the Supreme Court seemed very, very concerned at the notion of saying, we're going to go ahead and say it's okay for the police to, without a warrant, put a tracking device on your car and follow you around. In this particular case, because, we were actually talking about crime interdiction and not, some nefarious following around, say, of the justices themselves as they raised in oral argument. They asked whether that kind of tracking would be okay. And the attorney being asked that question actually said, well, yeah, because you're out there on a public street. And we've seen some cases touch on that issue too. I think that the justices overall, as you read the coverage of this, would have been fun to be there in the courtroom for it. Were creeped out, to say the least. They mentioned Big Brother and 1984 6 times during the argument. So I think they are concerned about letting this one stand. Evan, have you checked this out, and what do you think will happen in this case?
Yeah, I've read the coverage of the oral arguments. Kashmir Hill wrote a great summary of it, and Oren Kerr, also over on the Volokh Conspiracy, wrote a really definitive summary of what happened and some really valuable insight into what it was like in the courtroom. And talk about a really difficult case. And it's got plenty of creep factor. It really is not too difficult at all to be creeped out at the thought of the government putting a GPS device on anybody's car without a warrant, without any suspicion, without any reason to want to do it, but being able to do that and track someone's movements in public, gather vast amounts of data. Is that something that we as a society, one that has the Bill of Rights, the Fourth Amendment, the constitutional protection against unreasonable searches and seizures, is that something that we're willing to tolerate? And it's difficult to think about these things. It's, the reports are that the justices asked some pretty difficult questions about that, giving the appearance that they were troubled by the idea that, for example, Justice Roberts, Chief Justice Roberts, asked the government attorneys, so you're saying that you could bug any of our cars, and he was pointing at the 8 other justices on the bench there without a warrant. And the reports are that they, didn't take too kindly, at least in their countenances, to that. That's really something that's hard for us to think about. But the reason that it really does get especially difficult to think about is when you start drilling down and actually thinking about the Fourth Amendment, what it says and what the case law has told us about it since it was, enacted in the late 18th century. What the Fourth Amendment does, it protects us against unreasonable searches and seizures. Nowhere in the Fourth Amendment is the word privacy mentioned, but that's been built into the jurisprudence of the nomenclature by the courts, and there's this very important idea of the expectation of privacy that a person has. Privacy that we have. And, one of the important elements is a subjective expectation of privacy. That has to be shown, among other things, for there to be a legitimate Fourth Amendment interest here. And what makes this factual scenario different than other, the typical Fourth Amendment case, being somebody has a bag of marijuana in their desk drawer and the cops come to their house and want to search for it, or somebody gets pulled over and the cops, are looking for a bag of, cocaine or handguns or contraband in the car. What makes this one different is that this is tracking information wherever you are in a public place. And really, if you think about it at a certain level, what this is a composite of information that is made up of a bunch of tiny data points. Any one of those would not, by any stretch of the imagination, be subject to an expectation of privacy. If I'm driving my car down the highway, I cannot say to anyone with a straight face that is a fact that I should subjectively believe should be kept private. So when you put all that together, you paint this really, this is where the creepy factor comes in. You can track someone where they go, everywhere they go for a month or more. You develop this very detailed picture about it. And, in the composite, what is it that makes that something that is an unreasonable search and seizure a privacy violation under the Fourth Amendment, it's really hard to articulate what that is, and it's what makes me think that there's a fair chance that the Supreme Court might come down on the side of the government on this one. It's bizarre.
Yeah, it's really bizarre. On the one hand, this case seems really straightforward because the officers involved were really operating under sort of a Keystone Cops kind of scenario where they let the warrant expire and yet put the GPS tracker on the next day and also put it on in a different state than the actual state where the warrant was issued. So, you know, on the one hand, these guys just did not cross their T's and dot their I's. And I think that the court might want to just come down and say, look, this is the minimum that we expect from our law enforcement, is that they jump through the hoops that are there for them. But, you know, Evan, you raise excellent points about whether in the aggregate this is really something that a warrant can even be required for. Harry, what do you think? Is this something you're discussing in your classes?
Yeah, we do talk about this. What I think is interesting is the hostility from the court, but we always have to think about whether the court can articulate an administrable principle going forward regarding what are the appropriate technologies and limits. And the Supreme Court is always concerned about making sure that their case law has some sort of meaningful principle that guides future conduct. So it seems very hard to me for them to come up with an articulable principle there despite their hostility. So it's possible they could limit this case somehow to the facts, which has all sorts of problems on its own if they want to find out that this was unconstitutional. Or they might say, hey, look, there's nothing in principle that stops Congress or state legislatures from making this type of conduct require a warrant. This doesn't have to necessarily be a constitutional issue. It can just be a regular legislative issue. And they might say, we're not the appropriate governing body to make this type of decision. We encourage Congress or the state legislatures to say the police have to obtain warrants.
Right. That's something Cash Hill said in her article. And going back and looking at that, I see that Antoine Jones, the person in question here, was in fact busted for running a massive cocaine ring. So he was not just a tangential player. And they found that out because they tracked him for a month and they found him regularly driving to a stash house. And Cash Hill says at the end, I take it she attended the argument because she has a very detailed rundown here of what went on, that she fears that the court might just, you know, once again beg Congress to update the privacy laws to take new technologies into account. Beatmaster in IRC had a great question. Would removing the device, if you found it, if you were Antoine Jones or somebody else on your car, would that be illegal? My gut reaction says no, but who knows? I mean, if it were properly placed there with a warrant and you were ultimately arrested, I'm sure it would not help your cause. Do you think, Evan?
I hadn't even thought of that. So this is a matter of first impression going on, you know, between my ears here. Maybe some kind of obstruction of justice charge, you know, especially if it was there by, a warrant, you know, you're doing something to impede this investigation in the same way that if the cops were there with a warrant and they're knocking on your door and you somehow undertake further efforts to fortify the door so they can't beat it down with a battering ram. I'm totally making up that fact pattern. I don't know if that's ever been litigated as a Fourth Amendment issue, but something like that seems pretty far-fetched. I would hope not, because gosh, if you're going to just be taking care of your car and you're taking off bugs from it, that ought to be something that's not illegal.
And others in IRC are pointing out you'd have no way of knowing if it were there by a warrant.
Oh, that's right.
Find the darn thing. Yes, Harry?
Oh, I think there was somebody else.
Yeah.
Oh,
Karl.
Evan, I just want to jump in and ask you on this. As a layman, you were talking about expectation of privacy, and what always comes to my mind is, I will admit I didn't read the entire write-up. I was reading sort of the cliff notes, the summaries of what the implications of this were. But I'm reading this and I'm thinking, like you said, when you're driving your car around, there's zero expectation of privacy. You could even go as far as to say people go out of their way to make sure people know where they are. There's no shortage of self-inflicted tracking devices that people can volunteer and participate in. And my question really is it legal for someone to be followed around by law enforcement without a warrant? Is the issue simply that they're utilizing technology to be able to track people and follow people around more efficiently than they would if they had, the force to be able to have cars, black and whites on the road following all these people around? I mean, is this really just coming up because now they're able to do what they couldn't do more efficiently?
Yeah, go ahead. I think.
I was going to say that, we talk a lot about this. I've written a little bit about this idea that there's often an argument that, reduction in cost of doing things like surveillance or aggregating information is often just framed as a matter of degree, right? We're just making this more efficient. But when you cross some threshold of efficiency where you make the gathering of data so much more efficient, it actually becomes a difference in kind. And the law really needs to take that into account. And I think the justices really recognize that the difference between the technology in 1970 when some of the older case law came around and the difference of technology now is quite different, such that the analogy of the police officer following somebody around, which justified the technology back then, really needs to be re-examined in the light of these extremely decreased costs.
Harry, that really is an indeterminate question, isn't it? A little bit different than the question of liability under the tax code, whether or not this is a difference in kind.
Absolutely. It's fundamentally a policy issue, which a lot of the Supreme Court cases are. The Supreme Court is balancing conflicting interests, the legitimate interests of the police and law enforcement in trying to gather information on alleged criminals versus the legitimate constitutional rights of citizens to have restrained government.
Yeah, Karl, I think the answer to your question is yes, it's all about the technology and what it can do now, because one case that is before the court in considering this is an old 1983 privacy decision that involved the police having someone, not a police officer, put a canister in someone's car. It was something they were going to purchase, and they put a beeper on it. And so it got sort of clandestinely planted in somebody's car so that they could be better followed around with reference to the beeper. The beeper would beep more strongly when they were close by and would be fainter when they were far away. And the court found that procedure was okay. And lawyers in this case were trying to argue, well, really, this is just the same kind of thing. It's just a more sophisticated beeper, but it's the greater sophistication and what you can gather with today's technology that is really at issue here. And back in IRC, it looks like YA4 says it's easy to imagine that these devices could expand to collect in-car audio as well. So, yes, there's lots that isn't involved in this case that could be, and I think that's what the court is looking ahead to and trying to make sure that they anticipate. There is the question of whether that's the court's job or Congress's job, and I think that will play heavily in their analysis here and may wind up shading their opinion. Harry, any final thoughts before we move on from this?
Yeah, I think one thing to think about in these cases is that Karl brought this up, how the absence of efficiency is actually serving an implicit regulatory role when it comes to privacy. So in the past, before the technology, the government was restrained in all of these ways implicitly because they didn't have the technology to do that. And in translating it into a new world when we have these technologies, it's important to think about translating the dynamic from the past when the government was implicitly regulated to the present when they're no longer implicitly regulated by the absence of the technology.
Yeah, that's an excellent point. Evan? Any final notions about this?
Well, just to tack on to what Harry said, because that was really really interesting, and it's still just a question of where does this difference in magnitude switch over to be a difference in kind, so that it's a binary question of yes, the technology is the use of this technology here is a Fourth Amendment violation versus no, it's not. It's such a gray area, and there has to be a point along that spectrum where we draw a line and say, everything on this side of it is going to require a warrant, and everything on this side is not. And to me, that just seems to be completely relativistic, and we could have been making the same kind of argument in some kind of hypothetical past where we emerged into a world that had had newly discovered the benefit of optics, for example. There's a time period before cops didn't have binoculars or telescopes to spy on someone from a distance. Think about how jarring that would be to wake up one morning and learn that, oh my gosh, yesterday nobody could recognize you at a distance of 300 yards. Now they just take these little devices, put them in front of their head, and they're able to identify you. How shocking! This should be, that should require a warrant for them to be able to use binoculars. So, to me, we've got to take kind of a long view on this thing, a long view of history in integrating the technological changes in the ways that they're going to affect our jurisprudence on all these things. And I'm glad that I'm not one of the 9 justices who has to actually make a decision on this.
Yes, not the first time I've been happy not to be a Supreme Court justice, for sure. Evan, I don't know that this particular issue will be impacted by this decision in the Jones case when the court does announce its opinion, but it's possible that it could. You linked on Twitter to a great article by Peter Krusko over at Law Technology News on cell phone data and expectations of privacy, and specifically the cell site location information and how that is shared and gathered by law enforcement. Do you think that this case might wind up shading how law enforcement is able to go to cellular providers and find out where you've been that way?
Well, I think the cell location information cases are different enough from the GPS warrant requirement tracking cases enough so that I don't think that the analysis is going to bleed over too much in the minds of the courts. But that's just me talking. I really have no idea. The way I see them different conceptually is, we've got the Fourth Amendment issue arising from surveillance that we see in the GPS tracking cases. And so the question is, as I was saying, very early in the conversation, what we have here is a composite of information. Each point of information, making up that gestalt in and of itself is not private. Whereas in the cell phone cases, there's a much easier line to draw from a person's expectation of privacy in the abstract to their expectation of privacy in the actual concrete setting here. I look at these cases of the cell phone location information more like Fourth Amendment cases that deal with what expectation of privacy you would have in like a self-storage unit. You go and pay $25 a month, and you have a little space where you can stash your guns, or even if you stash stuff that's not contraband. That expectation of privacy there is much more clearly articulable as a privacy interest in those types of situations than the surveillance cases. So because of that distinction, although those issues might be first or second cousins to one another because they both have the Fourth Amendment as their common progenitor, I think that analogically they're different enough that we can safely think of them in different ways in different parts of the paradigm under the Fourth Amendment. No doubt they both come close to our hearts and our feelings of personal security, but after all, that's what the Fourth Amendment is meant to do in any event. So it's fun to think about these things and draw comparisons, but I think they're different enough that one case wouldn't be citing to another in this situation.
It is fun to think about, and it's fun to hear you use the words progenitor, analogically, and paradigm in the same sentence.
Hey, anytime. I'm here all week.
Yes. Thank you for that. It occurs to me that we really are talking about two different expectations of privacy with cell phone data, because cell phones can be used as tracking devices, not quite as effectively as a GPS device can, but close enough. I mean, they can sort of triangulate where you are and where you've been. And then there's also the storage locker analogy, right? There's actually data that is informational that the cell phone providers collect that has nothing to do with your location, but may have lots to do with what you've been doing.
Right. I liked how Karl said earlier, there's plenty of self-inflicted ways of betraying where you are. I like that he chose the word inflicted, because we're choosing to disclose a lot of that information, merely passively by carrying around our phones with the location service enabled.
Right. Harry, I'll ask you the same question I asked Evan. Do you think that this Jones case may wind up impacting how law enforcement can access the couple of kinds of information that we may consider private related to our cell phone transactions?
I don't think that this particular case will directly affect it, but I think it impacts very similar issues. There's a very similar dynamic that we were just talking about earlier, where technology has changed, but the law has remained constant over time. But the relative shift in access is fundamentally changed because of the technology. So a lot of the law is premised on physical location. But as more information becomes located elsewhere, for example, off premises, a lot of privacy law is concerned around people's physical houses and filing cabinets in their houses and who can examine what information. But more and more data is either moving through third-party services located off-site or into the cloud. And so the old conception of location-based privacy and control is really becoming quickly outdated, and the various doctrines from the law which protect on the basis of location and people's own personal control over data are consequently becoming very outdated. So the Supreme Court is going to be seeing a lot of this a lot more as technological changes only become more location unlocated.
Yep.
Not just that. If I could just dovetail on what Harry's saying, and we're going to be talking about it later today, these privacy issues aren't even just a matter of location. With all of the social networking, and again, we've got one of the stories we're going to be covering today has to do with what information can be gathered that, again, we've self-published, whether we initially put it out there to be private or not. How much of that information can be demanded in anything from a civil case in discovery to in a criminal case if there's something going on. Right.
Karl, you write for technology consumers and do your show with them in mind. Do you think that lay people really appreciate these issues very well?
I think most of the time the general consumer is petrified with regard to privacy. They're petrified that everything is going out there. Let me separate that. Let me quantify it again. The younger generation doesn't seem to care. They have no care in the world. They're putting things out there about their instructors that they're having classes with in college today, and they don't seem to realize that their instructor can go and read that might mean something. Or the younger than that generation, they're putting out things that might come back to haunt them when they're applying to college someday. They don't care. The older generation, or let's say, I'm going to be in trouble now either way. Let's just say the 40-plus generation, is
thank
petrified.
Goodness.
Yeah, I know. I had to think about that. Is petrified that what is going to happen with all of this information and how is it going to come back to haunt us? And they don't want anything to do with locations and sharing locations. They like Facebook because they like to be able to keep in touch with their friends. They like to be able to share pictures. But it freaks them out when all of a sudden they'll get an email from someone that they didn't realize, had access to their pictures because they didn't go through and granularly check off who can see this, who can see that. And some of the information that they had the assumption that was private turns out to not be private at all. I agree. I think we're going to be seeing a lot of these things coming up as especially the younger generation is going to start getting older, and some of these things that they're not aware of or not appreciating the severity of starts to come back to haunt them.
Yeah, and I think that actually the Supreme Court probably has that in mind as they consider this Jones case. That the most pertinent case that they have before them in considering the case before them now was decided in 1983. So, you know, they fully appreciate what long-term effects their decisions have and how, you know, even if youngsters don't know, you know, what kind of information they're putting out there and how it might be gathered, that we need to have policies in place that make sure that law enforcement doesn't overreach and that people's expectations are actually, their reasonable expectations of privacy are actually honored. So with that, I want to take a break for a moment. We're here with Harry Surden from the University of Colorado Law School, and Evan Brown from Hinshaw and Culbertson in Chicago, and Karl Wireless from My Tech Boss, and also the West Side Gadget Guy. He writes for a publication here in Southern California. And we're talking about all kinds of issues in internet and technology law. And what we've got as our first sponsor today is Ford. And we are really grateful for their support of our show. And I'm really grateful that they have the particular technology I'm going to tell you about right now in place. I'm particularly grateful for it today because I wound up this morning just taking my son to school behind the craziest driver I've seen, you know, since I used to live closer to downtown LA and see crazy drivers every day. Out in the boonies, kind of where we live, mostly people are very considerate and nice and wave you in front and let you have the right of way. This woman this morning, I swear, I don't know if she just had too much coffee or whatever, but she was a good reminder to me that there are nutty people on the road, and you need to be paying attention and making sure that they don't put you in a terrible situation. She, I don't know what I might have done to trigger this on her part, but she was very miffed at me. She drove by and flipped me off in a very hearty way, and then proceeded to actually physically park her car in front of me, put her hazards on in the middle. She's like in the third lane of a busy thoroughfare, and just stay there for a good couple of minutes while cars were going around us and I'm trying to get an opening in traffic to go around her. I don't know what I did to trigger her reaction, but, you know, I don't think I cut her off or anything. Anyway, it was a good reminder to me that we are desperately in need of things like voice-activated sync app link, which Ford puts in its cars, which enables you to control applications from your smartphone with simple voice commands while you keep your hands on the wheel and your eyes directly on the road on all the nutty people around you. With Sync App Link, you can do things like voice control Pandora in your car. I would have very much liked to turn on Pandora and calm myself down after this all happened. You can listen to your tweets with Open Beak just by asking with a simple voice command. And once your smartphone is linked to Pandora, for example, you can use voice commands to select your favorite station or make a new one. You can bookmark songs to purchase, and you can give songs a thumbs up or thumbs down. You can use some of the voice commands like play station classic rock or bookmark song or thumbs up or thumbs down. All of this without taking your hands off the wheel. And with OpenBeak, you can simply say read timelines or read replies and update yourself on what's going on in your social stream. And I know you guys have done this. You've checked Twitter while you're driving before. I know you have, and you haven't done it in a hands-free kind of way. So Sync is going to make sure that you don't get yourself in trouble with that. It's built on an API platform that allows Ford to continue to work with developers in the app community to bring apps to life with voice in their vehicles. Voice-activated Sync App Link is available in the 2012 Ford Fiesta. You can learn more about it and other technologies Ford is bringing to its vehicles at ford.com/technology. And we really thank Ford for keeping us safe and for offering these great innovations in their cars and for sponsoring This Week in Law and the TWiL Network. All right, folks, we've got Harry Surden with us today, and one of the reasons I asked Harry to come on the show is he's been doing some really interesting thinking and work on the subject of computable contracts, which are basically contracts that a computer can understand and can determine whether or not it has been complied with. So one interesting thing about computable contracts is they really cut down on the work for people like Evan and myself, taking lawyers out of the loop, which is a very welcome thing for people who are not lawyers. And they also just, streamline the court system. They make it so that maybe certain disputes don't ever have to make it to court, and that things are just more efficient and generally a nicer way of making sure that contracts are enforced. But they're also a long way from being very, very prevalent in our society. It's so much so that the greatest example I can think of a computable contract is in one of Cory Doctorow's science fiction books, where a couple of parties get into an accident and basically log on to IRC with their cell phones, and the whole thing is resolved in about 5 minutes as to who owes what to whom. And I think there's even a financial bank transfer that happens, and then they're all on their merry way. So I don't even think that's a contract. That was just a computable dispute resolution. Harry, why don't you...
Yeah, it's a settlement agreement, huh?
Yes, exactly. Harry, tell us what kind of work you've been doing and what's interesting in this arena right now.
Yes, well, Denise, you're quite right that we're in the early stages of the idea of computable contracts. Although it is happening out there in the world, albeit in really rudimentary ways. So there are a couple converging trends over the last 10 to 15 years that have set the stage for certain types of limited contracts to be computable in this way. And I'd say the biggest trend, of course, is the internet. People are interconnected in particular ways. But almost as important is a trend where particularly firms are starting to store their data that they used to store in paper form electronically. All right, so now the majority of the data in companies is in this sort of electronic accessible form, and they're sort of taking it one step further and making it what they call structured in the computer world, where they can actually have information about what that data is, unambiguous information about it. So there's a bunch of trends that are enabling computable contracts. And right now you see it just very simple contracts. So in particular, you see it in the financial arena with financial contracts where firms are making financial agreements completely electronically from computer to computer. And then the computer systems can actually tell whether the financial agreement has been satisfied or not, because, for example, say there's a derivatives contract that is referencing a particular stock index at a particular amount, right? So the resolution can take place automatically, and really the human is out of the loop in this instance. With that being said, right now the examples are very limited, so we're not at the point where the computers are going to be replacing lawyers anytime soon, nor do I think that is in the offing. But there's a lot of interesting work that can be done with these relatively simple contractual obligations by making them electronic and computable.
Right. The IRC channel is thinking exactly what I was thinking while you were saying all that all of this is somewhat reminiscent of the Wall Street meltdown, that automating financial transactions to that extent sounds a bit scary, in that, things are already pretty automated there already. But I guess perhaps some of that is unavoidable. Are you thinking that it might be the scenario for meltdown too as we continue down that road?
Well, I think there are certainly concerns with automating everything, but I don't think that should overshadow the larger point, because right now they're just simply automating the contractual obligations on top of the other electronic arrangements that they were already engaged in. So it's not a huge difference from what already existed. But I think there is some concern as you move to more and more automation, and I think some prominent critics of the financial crisis thought that some of the financial crisis could have been attributed to putting too much faith in automated models. Now, again, that being said, at the moment, at least, the state of the art in artificial intelligence and computer science is not such that very sophisticated contractual obligations are going to be automated by computers anytime soon. So Watson notwithstanding, which can get to the right answer in many cases when there is an objectively right answer. Many times in law, it's not the case that there is a right answer. There are just different reasonable competing positions that parties need to negotiate.
Right. So you gave an example of something that it's pretty easy for a computer to determine if, money is owed and whether money has been paid. And if all the parties are in agreement on that, then the computer can say, yes, this contract is, I can understand it and it's been complied with. Do computable contracts ever do more than that?
Absolutely. So one of the big benefits, so the main benefit why this is happening is efficiency, right? So in the past, you'd have to have a middle person look at a paper contract, match up some numbers, and then do what the computer can now do automatedly, right? So this is really an efficiency concern. But there are actually these new properties that emerge once you make contracts computable. You can detect contradictions among contractual obligations that you have. Say a company promised some set of goods to one customer and another customer simultaneously. Right now, it's possible to find something like that, but it's, in the paper contract world, such contradictions are basically buried among, the tens of thousands or hundreds of thousands of contracts that companies have to deal with. Once you make it computable, even simple contracts, all sorts of interesting and helpful properties emerge of that nature.
So how does this all jibe with the notion that as we move contracts away from paper, that we have simply the machines transmitting the text and receiving the text, and we don't really know, if there's a comprehension issue? I'm thinking of, for example, how Creative Commons lets there be a machine-readable form of the Creative Commons license that just is sort of going on behind the scenes, and you really don't know whether the parties involved have themselves comprehended what's governing their activity. And I'm also thinking of something we've talked about on the show a couple of times. We highlighted as a resource of the week in sort of a tongue-in-cheek way, this toss amend idea where if someone's presented with terms of service that they don't necessarily agree with or want to go along with wholeheartedly, that they would send back a machine-readable electronic modification to those terms of service and say, if you allow me to use your service, I'm doing so under these terms, not the ones that you promulgated my way. What do you think about all that, Harry?
Yeah, so you're quite right in highlighting these difficulties. I think right now there are limitations in where computable contracts are going to be useful, and in particular, I think they're not useful in areas where there's likely to be significant disagreement or uncertainty between the parties and negotiations. Now, that might not seem like a lot of situations, but in fact, actually, if you look at the vast majority of situations out there, there's often a wide level of agreement about what people want and certainty about what the parties are discussing. It's only in the rare cases that get litigated that we involve lawyers who discuss uncertainty. So there's a not insignificant number of cases that, in law school we call the easy cases that don't involve a lot of uncertainty or disagreement. It's interesting that you mentioned the terms of service generator, and I just took a look at that. My sense is that if you're amending the terms of service unilaterally as a customer, that may not be valid in court. There's actually a series of rules out there in the law that deal with an analogous situation among professional merchants, they call them. So it's pretty common for two firms that are buying goods from one another just send each other disagreeing contracts, and yet the transaction goes through anyway despite this disagreement. And they've a series of rules that say, they call it the battle of the forms, that help resolve any disagreements. I'm not sure that a unilateral modification by a user to the terms of service would be upheld if it materially changes the agreement that the company is giving. So a lot of companies online and companies out there in the world have these sort of take it or leave it agreements where they say, here are our terms of use. You can either agree to them or not. And they don't offer the opportunity to negotiate. And the courts have been pretty good about saying, look, consumers, you have the opportunity to walk away if you disagree with the terms. But if you do engage in the service, then you're going to be bound by those terms.
So, Evan, as you've been listening to this, are you ready to welcome our contractual robot overlords, or do you have some concerns?
Well, clearly, just as Professor Surden is saying, there are some things that need to be ironed out in all of this stuff. You know, it's left for the easy cases now, and from what I think you're saying, Harry, you know, the easy cases are, you know, to use the nomenclature that you've used in the paper that you wrote about this, those easy cases are the ones that are the most determinate. And right, am I getting that right? You know, under this notion of the variable determinacy thesis, right?
Absolutely.
Yeah, and so I mean, this, you know, it's really fascinating to see where the analysis has gone in your scholarship, most recently with talking about this in contract law, because the work that you were doing, you know, right before this in the paper called the variable determinacy thesis, this is just really an interesting discussion of, you know, this body of inquiry of legal informatics, and it's interesting to see the conclusion that you make that those situations, those legal contexts, those fact patterns that are presented to a legal official like a judge or a regulator or an arbitrator or whatever, they are subject to analysis, and at each point along the way in the analysis there are decision points. You know, like, is this a civil or a criminal case? Is this, you know, does this involve a tort or is it a contract case? You know, and you know, I guess ostensibly would go down to finer levels of granularity ultimately in the analysis to make a decision. And so, from what if I'm reading your paper and your scholarship correctly, it's those cases that are, you know, before the fact, predictable or determinate, that lend themselves best to this sort of automated legal reasoning. And it's so fascinating to think where this could go, because now with the computing power that we have now, with the state of the art as computer science gives it to us, you know, we're left to those easy questions, you know, figuring out tax liability for most people. Is this income? You know, what's the tax rate? Here's what the tax liability should be. It's so fascinating to think about as computing power gets more powerful, and more factors can be taken into consideration, and you know, that computers can be engaged in more abstract thinking, where this could go, broadening that scope of what is a determinant type of question, or at least broadening the area in which computers could fit into this. And so I guess one question that I would have, something that I'd be really curious to hear you comment on, Harry, is you know, this distinction that you've made between substantive legal informatics, where it is the computer that is actually imparted with some kind of semantic power, or at least the information that the computer processes is laid over with a template that gives it a certain semantic significance, semantic power to be, you know, quote unquote, understood by the computer. You know, where is it that and again, we're talking about a sliding scale here, and figuring out where we're going to draw a line in a gray area. Where is it that computing power can lead the computer to really be engaged in substantive legal informatics, actually making decisions based on the meaning that it has, versus, you know, what you've characterized as non-substantive legal informatics, which is like, you know, going and retrieving a case out of a database and having the lawyer read it, the semantic reasoning power being in the lawyer's brain. I'd be interested interested to hear, where we can kind of assign that so that we can make more, be prepared to make better value judgments as to what should lend itself to automated legal reasoning.
Yeah, I think it's a great question. And I actually teach a seminar where we spend a lot of time talking about this basic question. And I think there are a couple of issues to think about. One thing is, what is the state of the art of computer science now, and where is it going? And you never want to bet against the state of the art, of course, or make your judgments about the possibilities now. But it seems like just in terms of computers engaging in completely abstract analysis and natural language processing at the level of a trained attorney, we're nowhere near that area. But there's this distinct dimension, which is, okay, let's assume for the sake of arguments that we will maybe get there some way. Do we want computers engaged in these type of decisions? And I think that's a much tougher question, because ultimately computers are, ultimate law is regulating the relationship between human entities. So I think humans are, when it comes to things that are discretionary or conflicting interests, will not want to cede any or to cede less decision-making to the computer realm. So I think that's the axis that we have to think about. What is the ultimate set of rights and obligations that are being decided?
Right. So we've moved from 1984 to Terminator, Skynet at some point. Right. And I wanted to ask you, Harry, how much Kurzweil you've read?
So I've read a little bit. So let me just be clear that I'm very much in the camp of, what can we do now and what are the implications? And I'm much less of a futurist in terms of, what could happen then. So my general view is we don't know what can happen, in the future. So let's, be very much concerned with the current or near-term state of the art and the possibilities.
Got it.
Yeah, that's definitely a lot safer course, and it's not easy, or actually, I mean the opposite. It's not difficult at all to imagine situations where, regardless of how powerful our computing power became, so that it could engage in very abstract thinking and draw connections between and among very disparate points and come to some kind of value judgment in the process of this automated legal reasoning. It's not hard to imagine situations where we would not want that to be turned over to a computer, regardless of what the computer is like. The example I'm thinking of, say I am like a county court judge in a community that has these old buildings, and somebody wants to go tear down a historic building to build a Taco Bell. And, so some kind of community interest group comes to me as the judge and saying, Judge, enter this temporary restraining order stopping the wrecking ball from knocking down this historic building because of the rich cultural value that it has to us. And so one of the things that I would be thinking about in determining whether to grant a temporary restraining order or any kind of injunctive relief against tearing that building down is the balancing of the hardships. And, it's a very subjective, very human-centric analysis that I would have to be going after, looking at, what is the benefit of maintaining the status quo, namely leaving that building there versus letting it be destroyed by the wrecking ball so they can build Taco Bell. And that seems to be irreplaceable. That kind of analysis, the source of the sentiment that needs to go into that analysis needs to, in any event, come from an organic substrate and would never be one of those that we would want to turn over to a computing, artificially generated intelligence to come up to, because even though it can engage in this complex thinking, there's still at that basis is the irreplaceable origin of it being something that's fundamentally human. So regardless of where we get to, and I'm looking forward to reading whatever kind of analysis that you promise is forthcoming about some of these normative questions of whether or not automated legal reasoning is a good thing.
I can almost see, sorry, Harry, let me just jump in and say I can almost see people trusting an automated reasoning system more than a human one because of all of our human fallibilities and the possibility for bias and other, things coming into play that would make a decision unfair that you'd never know about behind the scenes. And you really can't bribe a computer or otherwise make it corrupt. I suppose you could, give it a virus or a nefarious program and interfere with it that way. What were you going to say, Harry?
Oh, I was just going to agree that it is quite true that a lot of legal decisions that look like objective analysis are actually masking either value decisions or policy decisions on the part of courts and legal officials. So this becomes very clear to law students once they go to law school, but it's not quite as apparent externally. And this becomes, and you've highlighted one good example with the wrecking ball. I think the GPS case that we talked about earlier is the type of case that is fundamentally discretionary in policy balancing that the Supreme Court deals with. And so a lot of law, it doesn't look like science in the sense that we're measuring, partially objective facts like maybe the distance from the sun to the moon. But rather we're looking at balancing conflicting societal interests between actors. And then, in that case, it doesn't really matter, as you say, whether a computer ultimately can make that type of decision. It's whether society wants to.
So, Karl, you're our lay person on the show today. Lots of folks in IRC have been bringing up Siri in the context of this discussion. You ready to start turning to that iPhone in front of you and asking Siri what your legal obligations are?
Yeah, I'm listening to this, and I'm just waiting for the right moment to go like this and say, "Okay, Siri, I need a contract between me and this guy saying to do this and that." It's ironically, as the non-attorney in this circle, you would expect that all jokes aside, this would all sound terrific. No attorneys, we can just make everything very objective and plug in what we want, and everything would just be perfect. But strangely enough, this scares the you-know-what out of me. When I'm hearing that, this is a simple contractual matter, and nothing ever seems to be quite completely objective and simple. There always seems to be room for discussion, debate, and certainly compromise. So when I see all this, and again, I'm sort of waiting for some type of an example that somebody might bring up where I would think, okay, that makes sense. That doesn't sound terribly scary. I would trust a machine to draw that contract up. In the back of my mind, I'm still thinking, okay, but who would I still turn around and want to call and say, will you just read this and make sure this is okay? So I guess it's really a testament to what you all do, that, at the end of the day, when you're looking to protect yourself and your interests, and I am certainly one to embrace technology, this just scares the you-know-what out of me.
Right. As Harry says, I think we're a long way away from having a lot of this be very automated, but we are moving in that direction. What were you going to say, Harry?
I was just going to say another caveat is that this is primarily occurring in the business and firm context, and I think it's quite a different story in the consumer, less sophisticated actor context where this is not happening as much.
Right. So some folks, go ahead, Karl.
No, I'm laughing. I'm thinking, okay, then I won't start worrying about it at this point. We're not looking to have this take off anytime soon.
Yeah, but I can begin to see, some consumer transactions that are very legal document heavy and just a burden at this moment being aided by this situation. Like, for example, what you have to go through in getting a loan and buying a house, all of the legalese that is thrown at you in that context. And as a consumer, of course, you're not reading those 50-page contracts and you're just signing and initialing all over the place and signing your life away, and you really don't know what's going on there. Actually, if some of that were going on with some sort of Siri-like agent acting on your behalf, because I don't think a lot of people probably hire lawyers in that context, that, it could aid the consumer as well.
You know, we already do engage in transactions without people all the time. You know, anytime, you know, you buy something online that, you know, that's fairly automated, you go to the market, and if you go to those checkout stands that let you scan your own items, and I guess Apple now has something like that at certain Apple stores where you can actually walk in, pick up something, scan it, and walk out with it. I mean, you are agreeing to terms of service. You know, you're exchanging goods for ink, you know, for money. So, I mean, there already is an element of that going on. I guess in my mind, the scary part is whenever there's something that's not clear cut, and I guess that's the defining line right there, is what is clear cut to me versus what's clear cut to other people is, you know, can be totally different. But it's I see what you're saying. I mean, there's definitely times when we would like things to be completely objective, and there's times when maybe we wouldn't.
Exactly. And one thing that Amazon seems to think is objective, but the publishing industry, not so much, is this whole lending library program that we're going to see. I think it's already been rolled out. We've got the Kindle Fire coming out next week. That will add more fuel to that fire. We're going to talk about that in a minute. But first, I'd like to thank our second sponsor for episode 137 of This Week in Law, and that is Netflix, which brings you thousands of TV episodes and movies instantly. That saves you time, money, and hassle. And believe me, the way that they make their material available across devices is convenience that I've never experienced in any other context, where you can start something on your phone and then get home and you have a bigger screen. You can pull it up again on your Roku and it's going to pick up for you right where you were when you left off. And it works across so many devices, your computer, your iPad, some Android phones, an iPhone. If you have a gaming console, that's definitely going to take care of you on the Netflix front. A lot of just standard consumer electronic devices that show up in your AV stack, like your DVD player, may well have Netflix right there built into it. It's so inexpensive and easy to use, considering what you get, just the amazing access to a deep catalog of movies and shows. And I just love being able to go down memory lane with Netflix and dig out all the stuff that I remembered from when I was a youngster and trot it out for the second generation now growing up in our home. Whichever way you choose to access Netflix, you can watch as many movies and TV shows as you want, anytime you want, and you can cancel anytime. You can try it for 30 days free if you go to netflix.com/twit. When you use this URL to sign up, it lets them know that we sent you there. We appreciate that greatly. And we appreciate Netflix's support of This Week in Law and This Week in Tech. And we hope you enjoy watching instantly with Netflix. All right, so Amazon is doing a really cool thing where you can borrow books on your Kindle. It launched last week, the Lending Library program. You can borrow up to one title a month free. And actually what they're doing is they are paying the publishers involved in this program every time a Prime customer, and it's only the Prime customers that get to use this Lending Library feature. They pay the publisher. And you have to have a Kindle, right? Yes, you have to have a Kindle. It does not work on the free app versions of the Kindle software. When someone, under all those circumstances, borrows a book, Amazon actually pays the publisher as if the book was bought. So that's a heck of a lot of book sales that they're going to be sending publishers' way, and a heck of a lot of happy customers that Amazon's going to have borrowing books like this. But the publishers are not happy, even though they're getting paid. They are starting to dig through their contracts with Amazon and see, hey, we don't know whether you're able to give our books away for free. Even if you are paying us, we don't know if we've authorized you to do this. And so there's a big article over on Publishers Weekly who have gone into the ins and outs of which publishers are grumbling and how it's the agency model versus the wholesale model that controls this question, and whether Amazon's going to face some legal challenges to what it's gone ahead and done here. Harry, have you looked at this at all? And would a machine be able to parse any of this?
No, I have looked at this, but I'm afraid these are one of those issues that involves conflicting interests of different actors that is somewhat indeterminate. But I think it's an interesting issue. There was a lot of uncertainty about the terms of the deal, whether or not Amazon was actually paying or not, that it have looked like it's been cleared up. So that Amazon actually is paying. So I think that changes the analysis quite a bit. But I'm wondering, thinking back in the bricks and mortar world, say Barnes & Noble were to buy a book and just give it away one a month to a customer, whether that would be considered okay, and to what extent existing contractual agreements between booksellers and publishers are able to exert control over post-sale activities in the real world.
Mm-hmm. Right, because it's like Amazon is buying the book itself and then giving it to its prime customers, but it's not it's not a physical book. It's a digital book, which seems to throw everything into a tailspin, doesn't it, Evan?
Yeah, it does, and it makes it so that you might look at these things as licensing arrangements rather than actual distribution agreements like under the traditional publishing model. So we're moving further and further away from that way that publishing has always been done. And I think the real important issue that arises from all of this is for us to look at what Amazon is doing here, and it's another instance where perhaps it's being renegade, playing loose and fast with intellectual property rights here, much like what it did with the cloud service that it launched sometime in the last few months. I lose track of time. It could have been 2 years ago. It could have been 2 months ago, whenever that was, without worrying about getting licenses from the music labels and all this. And so what I like doing in thinking about this, what Amazon is doing, rather than getting into the nuances of what these distribution agreements might say and what the agreements between the publishers and the authors might say, I'll leave that for the people over at Publishers Weekly and the real wonks who are so into the publishing industry that they spend all day thinking about this stuff. What I like looking at is drawing comparisons to this between the tension between technological innovation and content, drawing comparisons between this and what is happening with big content in terms of the RIAA and the MPAA and its support of SOPA, the Stop Online Piracy Act. Is that what it's called?
It's not called Stop Online Privacy. It is piracy.
Piracy. I was reading my script in my mind wrong, and I glanced over those letters wrong. SOPA and the Protect IP Act, the House and the Senate versions of these, purportedly draconian bills. We've got this tension between technological innovation and big content. Here with Amazon, it's actually kind of flipped on its head compared to the RIAA/MPAA versus the world and the domain name system. Here we've got in the name of technological innovation, namely Amazon doing what it does with its various means of providing the technological infrastructure for the distribution of this content, running slipshod over content generators' rights. We've got the authors here who are screaming and yelling, saying, hey, how are we going to get paid by this? Sure, the publishers are maybe a little bit confused as to, wait, Amazon, what are you doing here? It's not what we signed up for. But the publishers are, much more, yelling and screaming, saying, hey, we're not, how are we going to get paid here? So they're, kind of going directly to their publisher worrying about this. So if we look at I guess the point I'm trying to make is that there's a little bit of a juxtaposition of interests here, and one kind of exploiting the other. The actual writers, the people who are out there with pen and ink, working, eliciting the sweat of the brow to generate these books, are kind of getting run over by Amazon, the technology company, whereas the RIAA and the MPAA is the one that's getting accused of running over, technological innovation, shutting down the internet, killing the internet, in those kinds of things. It's interesting to see the way that those can be looked at in different perspectives and different arrangements, different alignments.
Yeah, and you raised an interesting point about Amazon too, that I tend to recently sort of sit back in awe of their legal team and the licenses they've been able to negotiate for all the material they're getting included in their Prime Instant Video library. But also their music offerings are quite extensive too, and yet, as you point out, sometimes they forge ahead without maybe getting all the permissions in place that some people after the fact claim they needed to. Harry, were you going to say something here?
Yeah, I think there's also another interesting legal issue in the background that might not be apparent. Historically, there's been a limit on copyright law called the first sale doctrine that evolved, a long time ago and before the digital age, that said essentially after the creator of a work sold, say, a book to the public, they couldn't control the uses once they made their first sale. So I'm sure book publishers would love to prevent the resale of their physical books, at flea markets. But under the first sale doctrine, their ability to control what happened to the book using copyright law was cut off. But there's been a trend over the last 20 years where creators of intellectual property say, we're no longer selling anything, we're simply licensing it. And then since we're licensing it, this first sale doctrine no longer applies. And now we can basically control what happens to our intellectual property forever downstream as it changes hand to hand. And it's particularly evident in the software realm, but also in digital publishing. Anything that looks electronic, creators of intellectual property are asserting more control. And I think it's interesting, the shift in balance. And I think that's a little bit what's going on here. And my earlier example involving, Barnes & Noble buying a physical book was sort of meant to illustrate that.
Right. It really feels to me like what we're seeing these days with Amazon is, in the early days, they came to be this juggernaut of retail. It feels to me like they're becoming an equally someone to be reckoned with juggernaut of entertainment and media. Karl, do you agree?
Yeah, I do. And what's interesting is I think that, the winner and all that you're talking about, the writers are losing, the publishers are getting paid, Amazon's, is paying for the books. At the end of the day, I think that, Jeff Bezos and Amazon, their philosophy had really been for a long time to, ask for forgiveness, not for permission. And, they really can't lose, because if they end up getting permission later from the publishers or from the different guilds that are licensing this content, then wonderful. If not, then, they can stand up and yell and scream and say, look, we're just trying to get this content out to the people. This is to try and help you. This is to try and make the material more accessible to more people. And, at the end of the day, people will say things like Denise just did, that, wow, they're really the contender when it comes to digital content, that they're the ones that are really going to be, pushing us into the future with regard to how is content like this? Is it licensed? How it's licensed, how it's relicensed, and how it's sold.
All right. Well, one thing I want to get to before we wrap the show is the fact that net neutrality, which was challenged in the Congress, the FCC's sort of watered down version of net neutrality, did not fall to that challenge, that the Senate killed the House bill that would have knocked down the FCC net neutrality proposal, which I guess, is not huge news, but since there had been a move to try and undo it, it seems like that has fallen by the wayside. Harry, do you have any comments on the state of net neutrality as we have it now from the FCC?
Yeah, I tend to think that just the threat of net neutrality regulation goes a long way towards helping to promote net neutrality without the regulation actually happening. And I think a really good example of this is that I think the very clever move that Netflix took in measuring the bandwidth and accessibility of their service over different cable providers over time, and then publishing that data as a sort of watchdog that we're paying attention and we know if somebody is intentionally degrading our service because of a conflict of interest. So I think we might be getting somewhere there, even absent regulation.
Right. Evan, were you surprised at all that what had become this sort of partisan attack from the right on net neutrality didn't manage to gain enough momentum to knock it down?
I don't have enough insight to know what things at a high level policy kind of thing in Washington are going to happen there. I think you can tell from the answer. I really have the way I'm giving this answer. I have no idea because it's one of those things that it of course was partisan. I never understood why it was partisan. Unless it's only because something as simple as Republicans are more pro-business and Democrats are more concerned about the public interest. I have a somewhat of a hunch that I may have overgeneralized a little bit, saying something there. So that because of that, I have no real idea as to truly why it was so partisan. And then it's always easy to point to so many of the other things that could have the Congress's attention to have not focused in a certain way on these things. So that's that's my limited perspective on it.
Okay, Karl, any net neutrality thoughts?
All I can ever decide when I read about some new change in the net neutrality position is that they just don't understand it. I think the reason that this has become partisan is because people are just running to their comfortable corners because they don't really understand what it is that's going on, what it's even about, or what's at stake. I think that in 10 years, it'll be moot anyway because there'll be new forms and new technologies for connecting to the internet. And, the main players right now will be, running around in competition. We'll find a way to balance things out anyway. But for now, I've never gotten the opinion that anyone has really gotten a firm grasp on what this net neutrality issue is really about.
Right. Well, one other legislative piece that is out there and very controversial, we talked about it last week on TWiL, and over at the roundtable, the Reporters Roundtable on CNET, Rafe Needleman's show, they had a great sort of 40-minute long discussion of SOPA, which featured Mitch Glazer from the RIAA and his take on why SOPA is not as scary as lots of people are making out. He received the the Mike Masnick treatment over on Tech Dirt, where Mike sort of point by point rebutted every single thing that Mitch Glazer had to say in that talk. So the SOPA conversation definitely continues. To sum up Mike's criticism, he just thinks that it's being characterized by its proponents as something that's going only after foreign sites. And, you don't have to be worried if you're here in the United States. This isn't targeted at you, but the fact is the language is so broad that there's quite a bit you could do with it that could be quite scary. Let me see. Harry, have you taken a good look at the new version of Protect IP and the streaming liability that has now bundled its way into SOPA? And are you as put off by it as many seem to be?
Well, one thing I'll say, this debate reminds me a little bit of the debate in the 90s over the Digital Millennium Copyright Act, where both sides were both correct and incorrect about their fears. But I think, there's something to be said about the law of unintended consequences, and the Digital Millennium Copyright Act, particularly the provisions that regulate digital rights management and circumventing technological protection measures had some serious unintended consequences. On the other hand, there were worries about the spawning of digital rights management when in fact a lot of companies have recently backed off, at least in the music realm. So I think there's reason to believe similarly, some of the fears of unintended consequences about SOPA are legitimate, but maybe not in the way that everybody is sort of catastrophizing at the moment.
Okay, what do you think, Evan? Is the rhetoric outpacing the actual danger of this law?
I think so, because it's something that's easy to attack because of that risk that it's going to be used in an overreaching way and that it's going to break the domain name system and all of that stuff. I mean, there are safeguards in place for the abuses on it, and those are carried over from the DMCA, the most important one being if you're going to assert that there is some kind of infringement going on here that should be acted upon. You have to have a swear to that it's true, and that there is the potential for being on the hook for saying things that are untrue, much like what there is in Section 512F of the DMCA here. So, even though it does have a lot of power and a lot of teeth to it, I think that in practical application, there will be rational forces in the way that it's used to make sure that it's that it's not overreaching. That's not to say that I like it or I think it's a great idea. I think that I want to be clear that I'm only addressing the issue of whether or not the outrage is justified. I think there are plenty of things that we could do to critique it, because it's unfortunate, because it's unfortunate that it's so often subject to harsh treatment. Mike Masnick, he's a great guy, he's a smart guy, he's a friend of the show and all that stuff, but he really pours it on with this stuff. And my fear is that the overall impression of SOPA and the Protect IP Act and other things like these will be that there's nothing good to it and that there's no benefit to it at all, when there really is an important interest that is needs to be addressed here, and that is the infringement of U.S. intellectual property overseas. That's something that is important. No matter how you look at it, few people could. I guess Stefan Kinsella might disagree with me, but only those who would say we should just abolish intellectual property rights altogether would disagree with the assertion that those are important interests that we need to take care of, and this is a mechanism for doing that.
Yeah, I mean, if that is a problem that needs to be addressed through legislation, I'd sure like to see it done in a way that specifically targets that problem and doesn't leave loopholes that, big buses could be driven through to do a lot of other damage. Karl, I know you're not a lawyer, but from a layperson's perspective, are you paying attention to SOPA? Because it does, affect so much of the way that the internet and technology are used and may continue to function. And it has some consumer ramifications as well. Are you nervous about it?
Well, what always comes to mind when I'm hearing about it is that these are all, eventually they'll get it just right, and they'll get the right balance and the right legislation in place. But I apologize, who had just mentioned, it's not going to impact the people that it really needs to, which are the people overseas. They don't care what type of IP laws we put into place. They're still going to be doing whatever they're doing now. And, sure, we'll have legislation on, our soil that gives us, whatever powers or rights to say they're breaking our IP laws. But in reality, then what are we supposed to do about it that we couldn't already do now?
This particular law actually does have teeth to it in that way because of the ability to shut off domains at the source because of the whole registrar and registry system and what's based in the United States. So unless people are willing to, keep jumping to other domains, this actually will be able to impact sites beyond the borders of the United States. It sort of extends our jurisdiction to be able to shut off foreign sites.
And just to be clear, I'm sorry.
No, go ahead. I'm just thinking about Pirate Bay and how you say jumping domains. Somehow these guys, they managed to keep the same domain and just change what country they're housed in.
Yeah, that's an interesting question, is how they would be impacted by SOPA were it to pass. Harry?
I just wanted to say, just to be clear, I want to say that I think there is a lot to critique and not like about the act. So my comment was also directed at whether the level of rhetoric was proportional to the fear, not whether the act itself is good, because I think there are some serious problems.
Right, exactly. All right, well, something else that could be problematic is when you are in the middle of divorce proceedings and there are disputes and disagreements flying around and accusations being hurled and discovery is going on. whether or not you're going to be able to gain access to your spouse's social networking and dating site accounts to rifle through and look for information. And this is something that Karl sent our way for discussion today and looks pretty interesting. Why don't you tell us what happened here, Karl?
Yeah, it's funny. I love these. I always get a kick out of this to see how how the things that we consider are for fun, like social networks for the most part, can come back to haunt us sometime. And you pretty much summarize what's going on, which is, you've got a nasty divorce, and you never really know, are they looking to go through the spouse's Facebook account to try and see, is there another woman? Was there any planning for this, or are they just doing it to try and be nasty? I think anyone, and I am not one of those, that's been involved in a nasty divorce, they just want to get to the other person in as many ways as they can, and that would certainly get to me. I mean, if somebody all of a sudden wanted to go through and start reviewing all of my social network communication, whether I had anything to hide or not, I think the last person I would want to be able to have a right to do that would be an ex-spouse or soon-to-be ex-spouse.
Right. And in this particular case, a court actually ordered the spouses, at least the court made it two-way. They had to exchange each other's login information so they could rifle one another's accounts, which I think that the court may have, had some... I wouldn't be surprised if this kind of thing were challenged, but in a divorce case, maybe that would never happen because the parties just want to get through it and get done and not take something like this up on appeal. But I think the court may have been a bit confused about, what you're able to publicly access and what you're able to do with a login, although he did go ahead and put a stipulation into the order that said neither party shall visit the website of the other social network and post messages purporting to be the other. So, at least he was sophisticated enough to realize that some damage could be done with this information. Evan, are you concerned at this discovery development?
No, I think that this was the right decision that the judge made in this, setting aside that question of whether or not the access of the other's account by the other would be a violation of Facebook's terms of service, and therefore, not an enforceable part of this order. IMAC AZ, Matt McCary in the IRC raised the question, isn't it just most states no fault divorce states, and so what's the relevancy of this? And I think that would go to the allocation of the marital assets. What would be discoverable information?
Custody issues.
Yes, all kinds of reasons that this would still be relevant. I think probably the most intriguing thing about this case from the human standpoint is the at the end of the register piece, and I think this was I know the first time I saw this, Kashmir Hill. She covers all this great stuff. She covered it, and then the Register picked up the story. The quote, it's at least at the end of the Register piece here, was the quote from the one of the party's lawyers. I think it was the husband's lawyer. He doesn't even own a computer or have an email address because of, to quote him here, it says, "I see the information people can get from computers in lawsuits and through hacking." He said, "They scare the hell out of me." So, he's definitely coming at this with a healthy dose of skepticism and maybe a little bit of luditry, if that's a term. Seeing the nefarious sides of this, and we're not even talking about putting GPS devices on people's cars. There's plenty to be fearful of without that.
Denise, something that I was curious about with this particular article, and maybe you can glean why it would be, why wouldn't they just say that they needed to log in and print out or turn over whatever information they were looking for, or all of the information they could get? What was the point in actually handing over login information? That, to me, just seems totally out of the realm of what's normal.
Yeah, I think we should appoint you to the bench, Karl, because that would be a better solution, to go ahead and make the parties produce the information and swear under penalty of perjury that this was all there is, and not, gain access to one another's
Seriously,
accounts.
I mean, that's pretty much how it's done, is it not? I mean, I've never heard of anyone saying they need to get email. If someone ever tells you that they have to turn over emails, they don't say, "I'm going to come to your office, give me your email account, and let me sit there and go through it and pick out your emails." They say, turn over your emails and you turn over the emails. I didn't understand why it was done this way.
Yep. Nor do I. Harry, I think Evan just came up with a good exam question for your class, having to do with when a judge orders something like this and it violates the site's terms of service. Where does that leave everyone?
Yeah, I'm writing this down right now. My exams are coming up. I hope my students aren't watching.
Right.
I don't want to give it away. My reaction is very similar to Karl's, just generally, which is this is not a new problem faced by the law. There's some one of the parties to a lawsuit has some information that's relevant to the case, and they don't typically say, if two corporations are suing each other, Corporation 1 gets the network password to Corporation 2 and can run through all their corporate files. Rather, they create a duty for them to turn it over during the discovery phase. So it's not clear why this was done in this way. And I don't expect things like this to continue, because I think judges will understand the ramifications of expanding into requiring password disclosures in this way.
Right. Joel Tenenbaum back in the news. I would be surprised if anything came of this, but you never know. Sometimes these requests do get granted. Just to bring people up to speed, this is one of the few RIAA file-sharing defendants who actually fought back, didn't settle. He's got Charlie Nesson and folks at Harvard representing him. He got hit with a $675,000 jury verdict that was reduced 90% by the trial judge. But the Court of Appeals didn't like that had happened, didn't really like how it had happened, which was that the trial judge had set it aside on constitutional grounds. The Court of Appeal said you shouldn't really be reaching those constitutional issues. If you want to reduce the damages, there's a procedure for that. You can do it. Unfortunately, that procedure, which is called remittitor, often results in a new trial when the side entitled to the damages doesn't like the reduction. So it wouldn't really have solved too much to go that route. Anyway, so the next procedural step that the Tenenbaum folks could take, and they did take, was to ask for a rehearing en banc, which is the entire panel, all the seated judges of the First Circuit, to take a look at this case and see if it was correctly decided before it goes ahead back to the trial court. And what Charlie Nesson is arguing is that it's unconstitutional to instruct the jury that it can return an unconstitutionally excessive award, which was something that the trial court determined. But it seems like he's kind of got some weird logic going on there. The appellate court didn't want the trial court to reach that constitutional issue, so I don't know how far that argument's going to go. But that's where things stand with Joel Tenenbaum these days. Harry, you think they've got any prayer of getting reversal from the en banc panel, or even getting reheard?
I think this is a tough issue because it's a very murky area of law. So the Supreme Court has roughly said there has to be proportionality from the harm that happened to the damages that are awarded, but it's not really clear what makes something proportional or disproportionate. So I think that's part of what's going on. And also there's a strong policy favoring jury verdicts and judges not overruling jury verdicts in particular areas. So I think it's a really hard issue here. I think this is a long haul here.
Yeah. What do you think, Evan? Is this just a procedural hoop they're jumping through, or do you think this might go somewhere?
At least three things here. First, I think every time in the show you say en banc, that bells and whistles should go off and confetti should go flying. I don't know. That's just
everyone drink. Got somebody else asking for an en banc rehearing.
Right. It's just the way it sounds. It's like some onomatopoeic or something. The second thing is I'm sick and tired of hearing about Joel Tenenbaum. I hope this goes away soon, just because case has been kicking around for more than 5 years. I'm sick of it. Third, I think that it's This constitutional issue is one that the court is not interested in hearing at all at this point. They made that clear that it was too soon. So why are they asking to rehear it again on the very issue that they said that should not have been reached in the lower court? The easiest, quickest way to dispense with this for the circuit court here is to send it back to the trial court where they already sent it. Let the trial court worry about it, hopefully for not another 2 or 3 years. So we have to keep hearing about this kid.
Yep, absolutely. Karl, any thoughts on RIAA defendants in general?
I just think it's ridiculous. The RIAA has got it completely wrong. These are the people that are into their product, and you're always going to have a handful of pirates. You're always going to have a handful of people sharing. We used to make cassette copies of cassette tapes for friends, right? I mean, we all did that, and somehow it wasn't the end of the world. It didn't make the industry come crashing down, and I think they've just got it completely wrong to begin with.
All right. Well, we'll continue to watch and see if Joel gets any relief from the First Circuit and what happens when they ultimately go back down to the trial court, which is their likely next destination. We've got our resource of the week for you to share. It is courtesy of the Social Media Club site by attorney Chrissy Skelsey. And she has written a great piece on legal questions to ask when creating social media policies. And she gives some good background on the National Labor, NLRB, guidelines and various decisions they've made about social media policies lately, and some good threshold questions to ask if you are a company, a business, trying to give your employees some guidance in how they should use the internet and social media. And, you could get as detailed or simple with those policies as you would like, but she gives some great ideas to sort of frame the discussion as you are getting ready to give them those guidelines. So thanks to Chrissy for our resource of the week, and I encourage you to check that out. We'll put the link in the discussion points for the show, which you can find at delicious.com/thisweekinlaw/137. And our tip of the week for you is from Jonathan Bailey, our friend over at Plagiarism Today, who writes great tips. And this one is on how to write a copyright notice. And as he points out, you don't even really need to have a copyright notice, but if you choose to have one, he gives you all the elements that you should have and how you go ahead and put one together and how you should think about it and what it may or may not do for you. So thank you, Jonathan, for writing a great tip on writing copyright notices. And as he points out at the end, there are some great examples of folks who get really creative with copyright notices. He doesn't hit on any. He says maybe he'll round some up in the future. So we'll hope to see some of those, because every now and then you stumble on some really funny and good copyright notices that don't just bore you to tears with their legalese.
I thought you were saying that people do them in like needlepoint or something.
Oh, well, that would be even better. Yes, exactly. Yeah. Cross-stitched copyright notice. But he does point out that you can either say all rights reserved or some rights reserved. You have to think about exactly what it is that you're permitting, whether you are licensing some of your work or not, and how you're licensing it. So Jonathan gives a great framework for thinking about that over in this November 8th post at Plagiarism Today. So, guys, I think we've pretty much made it through our material here, and it's been a busy week in the internet and technology legal arena. We really appreciate your helping us make sense of it all, Harry Surden, and you're helping us get ready for the coming contractual apocalypse when the machines all take over.
Absolutely. So we can welcome our new computer overlords down the road. But Thank you for having me. It's been a real pleasure.
It's been really fun to chat with you, too. I'm thrilled we were able to get you on the show. Where can folks find you offline, and do you have anything in particular you might want to point them to?
Yes, I think the best way to contact me is through my law school bio page at the University of Colorado Law School, and has various publications as well as contact information. And feel free to contact me with more questions.
Great. Thanks so much. Evan, wonderful to have you back in commission.
Yes, it's great to be here. Really enjoyed our conversation. This was everything I hoped it would be, talking to you all in this. And I hope everybody listening and you all will join me on Saturday in cheering for my alma mater, Wabash College, as its football team plays its rival DePauw University in Greencastle, Indiana this weekend. This is the battle for the Monon Bell. It's the oldest sports rivalry, college sports rivalry west of the Alleghenies. So go Wabash.
Go Wabash. Get that bell.
Thanks.
It's
Yes.
like Stanford and Cal and the Axe, but I'm sure that was a few decades down the road from the rivalry that you were speaking of. So that's cool. Thanks for that. Folks can find Evan at internetcases.com. Of course, he's at Internet Cases on Twitter. And Karl, the tech boss, over there at My Tech Boss. Tell us what you're doing over with your Tech Boss show.
Recently, maybe 2 months ago, we launched a technology satire YouTube channel. And didn't really know if it was going to be well received or not, but I'm happy to say in the last 60 days, we've gotten something over 8,000 subscribers on YouTube and a couple 100,000 views. So apparently we've struck a nerve and we're having a good time with it. We should have you on one of the shows.
Oh, great. What are you lampooning exactly?
Everything.
Perfect.
Everything and anything. We do. The theme tends to be the rules, and there'll be the rules of Bluetooth. You're not supposed to use your Bluetooth headphone when you're walking into the restroom, that sort of thing, and what happens when you do these things incorrectly, and some satires on Siri and things you're not supposed to ask Siri and things like that. Just a lot of fun, really.
Oh, great. Well, we look forward to seeing more from you on that. And folks can follow you, of course, on Twitter as well. Karl Wireless, you're over there. You're on the Google Plus, too. And so is TWiL, by the way. We established our Google Plus page over there this week when Google allowed people to do so. So you can find us there. We're TWiL on Google Plus. And we've got our Facebook page, too. That's facebook.com/thisweekinlaw. And you can always email me. I'm Denise at twit.tv. You can find me on Facebook or Google Plus or Twitter. I'm D. Howell over there. Love to hear from you between the shows. Know what's on your mind. Know what you think we should be talking about next week on This Week in Law when we come back on November 18th. And until then, we wish you all the best. Stay out of legal trouble. Talk to you then. Bye-bye.